The Video Privacy Protection Act was passed in 1988 to protect the privacy of video cassette rental information. Though this technology is outdated, the law continues to have a big impact on the website and application development. It basically prevents a rental company from disclosing an individual's personally identifiable video requests, viewing habits, and without informed written consent of the user. This, I think, stemmed from the hearings on Judge Bork when he was going for the Supreme Court, and it was some of his video rental information may have been leaked at that point in time. The law basically defines videotape service providers as any person engaged in the business in or affecting interstate or foreign commerce of rental, sale, or delivery of pre-recorded video cassette tapes or similar audio-visual material. So you got to think to yourself, well, how does this apply today? This is old technology. In fact, it's hard to even find VHS recorders and tapes any longer. But the definition is very broadly interpreted by the courts. So if you think about what it's protecting rental information regarding content that a user is either viewing or reading. And in the 2012 case in federal court, it was ruled that Hulu's online movie streaming service is covered by the VPPA. So the consent must be separate and distinct from any other legal or financial notice, either through a pop-up or with an affirmative act, such as clicking on a button to agree. The Children's Online Privacy Protection Act, or COPPA, restricts the online collection of information from minors who are under the age of 13 years. The FTC enforces this law, and it applies to two types of website and online services: those that are directed at children under 13 and those that have actual knowledge that they are collecting or maintaining information from children under the age of 13. To differentiate whether a site is directed at children under 13, the courts will look at things like subject matter, visual content, use of animated characters, children-oriented activities, the age of the model, use of celebrities that appeal to children, language or other characteristics of the service, and whether advertising on the site is directed at children itself. If covered under COPPA, the websites and the online services must provide clear notice on the site that they collect information from children and how they use that information and the disclosure practices for the collected information. The website must obtain verifiable parental information before collecting, using, or disclosing any personal information from children under the age of 13. The type of information they might collect is first and last name, physical mailing address, online contact information, telephone numbers, social security numbers, geolocation information, screen or usernames that function as a contact info, persistent identifiers that can be recognized as the users, photographs, videos, or audio files containing the child's image, or information on the child or parents collected with any of these identifiers. And verifiable parental information that you might use as consent are like signing a consent form and returning it by postal mail, fax, or electronic scan, use of a credit card or debit card or other payment mechanism that notifies the holder of the activity, the phone call from a parent, parent connection to a company through a video conference link, and other forms of government-issued identification such as a driver's license, passport, etc. And in some cases you can use Email Plus if the collected information is only for internal operations and not passed on to a third party. And this can be done using SMS messaging or a delayed second email message.